Okay, terrific. Um, First of all, we're going to try to get through a lot in an hour. I've done live classes where we spend 2 hours in this material. So I'm going to put up some slides rather quickly. We're going to be able to get you copies of the PowerPoints if you want them from your chapter. So don't feel like you got to start scribbling down as fast as I talk. Also, take a moment if you want to jot down my contact information on this main slide. If anyone has a question that they want to send directly to me, I don't have a problem with that. If anybody has more than a question that they want to talk to me about, I don't have a problem with that either. So I'm just going to give you another few seconds, take a screenshot of it, whatever, you got my information. So let's dig in. We're in a fairly challenging environment. And by the way, this is something I was saying a long time ago before we've had some additional challenges. We see lawsuits for injuries. Right now, I'm in the middle of defending about 5 or 6 drowning cases and a couple diving cases, customer disputes, issues with GC and subs, government investigations on occasion, consumer protection laws that were well intended, but tend to sometimes go overboard. I think the folks in New Jersey have a particularly acute sense of that, with exposures for class action. And we've seen contractors prosecuted for fraud. We have new and evolving safety laws and codes and standards, and we have COVID issues. We've had directives, telling us to stay home, what we can go back and do. We have federal laws about how we deal with our employees and the like, and everybody's worried about what will happen if somebody at my job site or one of my customers gets it and claims they got it from me or one of my workers. So I'm going to get to that in a little bit as we go through. First of all, a lot of the answers to your problems should be in your contracts forms. If you're building pools or servicing pools or renovating pools or selling products, you need to have contracts that protect you. A lot of the contracts that I'm asked to review, and this is in Pennsylvania, New Jersey, New York, Connecticut, about 20 other states too, I see forms that probably predate VHS recorders and certainly predate AOL. So a lot of them don't have the proper right of rescission, or it's not an adequate font. They don't mention escrow obligations were required, and virtually none address COVID. And typically, a lot of consumers, particularly those who are getting concrete pools where you don't have a liner or a fiberglass shell that comes with its own package, are not getting the critical safety information they need. So what are the risks? Well, obviously, we've had diving cases over the years. There's been a few recently in the Northeast. What I see is that typically manufacturers are walking away from these cases. And sometimes the builders are left holding the bag because they didn't do what the manufacturer told them to do. We see drowning cases. Occasionally, it's an above-ground pool where people left the ladder in. It could be a residential pool where nobody was looking, or public pools. Entrapment, I think we've pretty much slayed that dragon as long as we have the right material on there. Occasionally, if there's bad or old wiring, there's electrical shocks, illnesses, and obviously now COVID. And we get customer disputes. And if they're not happy, they take you to court, or sometimes even worse, they go on Yelp. I mean, I know a lot of friends, my kids' friends, somebody pisses them off in the least. Whatever, they're ordering something, or buying something, bringing something back, whatever, the first thing they do is they go right to Yelp and every other site they can think of. And a lot of times these problems can be prevented with clearer, better contract forms. And that's exactly what we need to address and prevent consumer fraud claims. Also, contracts with GCs and subs. So if you're getting work from a GC, then make sure you review what's in their contract that they're asking you to sign on to. I've worked with a number of pool contractors in pushing back against GC language and saying, wait a second, I understand that's your form, but we've got some issues here, and we go back and forth until it's good. And if you're hiring subcontractors, make sure that you have the right language to protect you there. So the first thing we want to make sure we're not doing is violating federal laws. Obviously, we've all heard about the Virginia Graham Baker Pool and Spa Safety Act, the VGB, but there's also the Affordable Care Act, there's OSHA, I'm not going to go into ADA, American Disabilities Act. We've had so many classes on that. We'll probably have more. It's just too much to try to swallow during this short time. The Telephone Consumer Protection Act, the Fair Labor Standards Act, which talks about minimum wage and overtime and the like, and the Family First Recovery Act and the CARES Act. So first of all, we know the VGB, all suction fittings sold or installed after 2008 must comply. It's the only ones you can get now. So you're going to get the right coverage, but you got to make sure that they have the right rating. So if you got 2 drains, the maximum system flow, each cover has to have a rating that exceeds the maximum system flow. And now that states like Pennsylvania and New Jersey are adopting the International Swimming Pool and Spa Code, inspectors are really paying attention to this. Public pools all have to be retrofitted with compliant fittings, and all fittings have to be installed in accordance with the manufacturer's instructions. So if the manufacturer says you need a certain sump, you need a certain sump. If it tells you a specific distance between the cover and the sump as a minimum, then you have to have that minimum. The other thing that's very important about the VGB, every suction fitting has a useful life expectancy stamped on it. 3 years, 5 years, 7 years, I don't know any that go beyond that. If you got covers out there that are beyond that, it's not a bad idea to use that as an opportunity to reconnect with your customers and say, hey, we installed the latest and the greatest, but now it's past its useful life. We recommend that you let us put new covers in. Okay, the CARES Act. First of all, we have the Payroll Protection Plan loans. This is not a liability issue. This was a bit of a benefit to a lot of people, and allowed people to apply for loans, which they could use to pay payroll and certain other specific expenses. We did a whole webinar on that at PHTA, which you can probably find on their website if you want more detail. But the bottom line is, make sure that you're using the money for the purposes permitted, especially if you plan to apply for forgiveness on those amounts. The FFRCA, one of the things it requires 2 weeks paid sick leave at the employee's regular rate pay where the employee is unable to work because the employee is quarantined. And this goes through the end of this year. 2/3 pay of caring for a family member in quarantine and 2/3 pay of caring for a child where daycare or school is closed. COVID must be the reason for the absence. And if you got 50 or fewer employees, then there are exemptions. Another law to remember is OSHA. OSHA talks about as specific requirements are reporting illnesses and injuries, whether it's COVID related or otherwise. So there's a link here. Take a moment, take a screenshot of it if you want. You'll get the PowerPoint if you want it as well. That's something to actually take a look at when you have a little bit more time. OSHA about 3 or 4 years ago also updated their rules on silica exposure. Basically, if you're dealing with that kind of thing, if you're grinding concrete, for example, then there are 3 ways that you can comply: using their table, using empirical data you get from your source, or medical monitoring, and nobody wants to have to go through that. So really look at those 2. Basic workplace safety. Just remember, the construction site, the backyard where a job is being done, is a place of work. It is governed by OSHA. And the normal precautions you have to take when around moving equipment, when around heavy equipment, have to be followed. You don't want this, especially falling into a pool. Now, a few words about the FLSA. It allows for collective or class actions, and it requires posting and record keeping. It provides a federal minimum wage. And I assume just about everybody's making over the federal minimum wage, but it also, and by the way, states can require a higher minimum wage. Localities in many states can require a higher minimum wage. They can't let you get away with a lower one. Overtime. If you work more than 40 hours per week and you're an hourly employee, you get 1.5 times your rate. Now, what is included in those 40 hours? The FLSA has a whole bunch of FAQs on this, but basically, if you're making people travel from site to site, that's covered. That's part of their work week. If they have to go to the office first and then travel to a site, that's covered. If they're commuting to the first place of work that day, that's not covered. Also, there is an exception for what we call a white-collar exception, and that's for people who do not fit within the typical blue-collar criteria. So when I say blue collar, we talk about carpenters, electricians, mechanics, plumbers, iron workers, craftsmen, etc. People who get their hands dirty in the field are governed by the minimum wage. They're not exempt. Who can be exempt? First of all, people who are on a salary basis, who are making at least the figure I have up here. And if it's an administrative person, then that person has to have a primary duty of managing or overseeing people, directing the work of at least 2 or more full-time employees or the equivalent, and to hire, fire, or be given significant weight in the decision to hire and fire. That is the executive exemption. The administrative exemption, which is typically for people in the office who do dispatching and things like that, is if your primary job is office or non-manual work related to the management or general business operations. And the person has a certain amount of discretion and independent judgment. So you got somebody in the office, a couple people in the office processing bills, things like that. They get paid a salary. That salary is equal or greater than this number that I just went back to. They are exempt. You don't have to pay them overtime. And finally, professional exemptions is typically for someone who has had some advanced field of science or learning. I don't think most of us have people like that on the payroll, but the bottom line is those are the 3 types of salaried people that you don't have to pay overtime to as long as their salary equals or exceeds the number on the screen here. You have to post notice of the FLSA requirements at your place of work. If you want to know what the post is supposed to look like, go to this link. They'll give you one, you print it out, you put it up, you've complied with that particular requirement. It's fairly simple. I just want to talk briefly, because we could spend a whole class on wage and hour. I want to talk about the kinds of records you need to keep. You need to have the employee's name, social security number, or identifying number, address, zip code, birth date, if younger than 19, gender and occupation. You have to, your records must indicate what time and day of the week do that work week begin. You can't keep changing it. You could start the week on Monday to Sunday. You could start it Tuesday to Monday. But whatever it is that way for your hourly employees, and you can't monkey around with it. That's what it's going to be. So you need to identify what that is. You got to identify how much they're being paid during each period. And if they are subject to the overtime rules, how many hours they worked each week, the basis on which the wages are paid, i.e. per hour or per week, what the hourly pay rate is, what the weekly straight time earnings are, what the overtime earnings were, and any additions or deductions that you're taking from the employee's wages. All of those are records you have to keep. So if somebody comes bringing a lawsuit or a claim, you have to have that information to defend yourself. Another topic I want to spend a few minutes on is employee versus independent contractor. In California, some of you may have read this decision in California and the new law there, basically saying Uber drivers and the like are now employees. Other states are starting to move in that direction. And in New Jersey and Massachusetts, they go by what's called the ABC test. If the work the worker is performing is outside the usual course of the hirer's business and is engaged independently and controls their own work, then it can be an independent contractor. But in those states, if what the worker is doing is inside the scope of the usual hirer's business, they're an employee. So if you have people who are your regular crews, they're employees. If you have to once in a while periodically hire a fence contractor or another contractor, that's where the independent contractor exception may work. Another useful thing to keep in mind, again, probably worth a half hour on its own, but a lot of people now are turning to agreements to try to protect themselves. You hire people, you train them, you expose them to your customer base, especially if they're a service company. And the next thing you know, they want to pick up and leave and open up next door and compete with you. And there are limited things that you can do to stop that. Now, a lot of companies are trying to get their employees to sign non-compete agreements, saying basically, if you leave or I fire you, then you can't do this type of trade in this area for a certain amount of time. And the courts are really looking at that very narrowly and saying, wait, is that really a legitimate need for the employer? If it's somebody at the top of your company, the person with the brilliance, the design, the one who knows all the customers, the boss, the VP, it might make sense. For a person as part of a crew, a regular person on a route, it's not going to hold up. What you can do, however, is ask all your employees to sign confidentiality agreements, which prohibit them from disclosing anything that you consider to be a trade secret. And the agreement would identify what you would consider to be trade secrets. You can also get away with much more easily having them sign non-solicitation agreements. So for example, you got a service person running a route, you can have them sign an agreement saying that if they leave, especially if they leave on their own, then for a certain period of time, say 6 months, that's probably reasonable, a year might be pushing it, they can't call on customers that they serviced while working for you. They can still open up shop next door, but they got to go find their own customers or at least wait 6 months before they start calling on yours. So, all right, now let's talk a little bit about consumer fraud. In most states, consumer fraud means false advertising. One of the most common examples, if you're in a retail establishment, is announcing the price after a deduction and rebate, saying new reduced price is X, when it turns out X was always the real price in the first place and it's not really a discount. So fake discounts is one of the ways that a lot of retailers get into trouble. False promises or representations of material facts. A misrepresentation, and especially in New Jersey, because they're the ones whose law is probably the biggest pain in the you-know-what. Misrepresentation is a statement of fact that is untrue, even if you didn't know it was untrue at the time. And it covers not just customers who buy from you, but even companies that you attempt to sell to. And it can also cover representations made on your website. So one of the things that's good to do is every once in a while, look at your website, make sure whatever representations you're making are you're willing to back up. Your contracts in New York and New Jersey, and I believe Pennsylvania as well, they have to include a 3-day cancellation period, reminding them of the right to cancel within 3 days. This notice must be, as you notice the font I'm using here, conspicuous. It's got to stand out. Your contract must properly identify who you are and any sales representative who was involved. It has to indicate, it has to show that you have the minimum insurance requirements. You got to enclose the total price, including all finance charges. If you're charging by the hour, you got to indicate what the hourly rate is. You've got to put in a start and completion date. You've got to be clear about your guarantees and warranties. If you want to maintain the right to claim a lien in the event of non-payment, you need to say that in your contract, and your contract needs to describe the materials that are used. Now, a lot of you are going to say, wait a second, how can I promise a start date and a completion date? There are so many things that are out of my control. The answer is it's a challenge, and there are things you can put into the contract that will help protect you on that, and we're going to get to that in a couple minutes. Again, these are the things that need to be in your contract, as well as any contingencies that may prevent you from performing as promised. And again, these are the things that need to be conspicuous. Okay, so before we come back to the contracts, I wanted to spend a few minutes on codes and standards. This is the International Swimming Pool and Spa Code 2015 edition. It is now in place and in effect in New Jersey and Pennsylvania. If you don't have a copy of this book, I strongly recommend that you reach out to your chapter, to NESPA or PHTA, get a copy. It's not that expensive. It can be a lifesaver, because when code officials are now going to look at your job, this is the book that they're checking. And the ANSI 7 standard on entrapment is actually reprinted in the back of this book as well. All of the important nuggets in the ANSI 5 standard for residential pools and the ANSI 1 for public pools are in here. So again, if you're building pools, renovating pools in New Jersey or Pennsylvania, this is the new Bible. Again, this code is based on the ANSI APSP, now ANSI PHTA standards. And it's written in code speak, again, so that the inspectors know what they're looking at. So what does it mean? What it really means is that you, as the educated builder who took this class, who's a member of your chapter, who bought the book, when you follow the code, your jobs are going to get approved. When the competitor who undercut you on price, the idiot with the backhoe in his yard, doesn't know about this and doesn't follow it, his or her pool won't get approved. So I think what it does is it helps all of us stand out. It helps us get business, because when we call on customers, we can say, hey, your state has adopted this code. I know you're talking to some other contractors. If they don't show up holding a copy of this, that should tell you something. It separates the professionals from the unqualified. This is quickly the list of ANSI APSP standards that are in effect. The ANSI 7 standard, again, if you buy the code that I just said, it's going to be in there. The ANSI 5 standard, if you're building in-ground residential pools, I highly recommend it. The 1 standard for public pools. The 2 standard is in-ground public spas. It's all up there, so I'm not going to spend any more time going through each of them. Again, and if you're working in the public sector, every state, New Jersey, Pennsylvania, New York, and in some cases, individual counties have their own public pool codes that cover design and construction and operation and maintenance. Okay, so now let's talk about the contract, because most of these problems are going to be addressed and hopefully eliminated with proper contract language. The first rule in any contract when you're doing work is, and this is true when I do a retention letter for some of our client, and that is you need to specify what you're going to be responsible for and what you are not going to be responsible for. Don't assume that if it's missing from the contract, it's understood that it's not your problem. You may understand that you're not doing barriers, but if you don't say that in the contract, your customer probably doesn't know that. So, who's doing barriers? Is it your responsibility, or does the customer have to find somebody? Who's doing the backfilling? Who's doing the deck? Are you doing the gas or electric, or does the customer have to hire somebody? Now, when I say you're doing it, meaning either you're doing it or hiring a sub, that it's your responsibility. Who's doing the drainage around the area of the pool? Who's responsible for getting the permits? Who's responsible for getting the C of O? I can tell you right now, I've done about 40 different contracts in the last few years, and no 2 contracts have the same exact answer for all 6 questions. Again, most of these states, you have to put in a start date and a completion date. But this is where you protect yourself. You have to list all the things that can derail the date. So when you list the start date, you want somewhere in your contract to say, the start date is dependent upon A, B, C. It's dependent upon having the permit. If there's anything that stops you from getting the permit, that's not your fault. It's not your responsibility. If other people's work has to be done before you can start, then your contract needs to say that we may be delayed because of non-contractor work. And if it is, then, we add that time. Also, that the start date may be delayed due to unexpected conditions, whether it's weather, whether it's COVID. For example, if there is an order directing you to stay home or reducing your capacity, then you need to make sure you're covered. Now, a lot of people seem to think that by putting a general, we call force majeure clause in the contract, you're covered for COVID. Unfortunately, a number of courts recently have not agreed. So, right now, most of the contracts I've seen, they say, yes, we're not responsible for delays caused by extreme weather, hurricane, act of God, etc. Without getting into anybody's religious views, not every court considers COVID an act of God. The point is, I think it's a good idea to put something in your contracts, or even to just, if you like your form as it is, to create a rider that says, in addition to the following term, to the attached terms and conditions, we are not responsible for any delay caused by inability to have a work crew because of COVID illnesses, instruction, prohibitions against doing the work, et cetera, et cetera. So again, COVID-proofing your contracts. You're not responsible for delays due to forced closing, due to illnesses to the customer or the crew. I mean, if the customer tests positive, you don't want to be there. If some of your crew tests positive, you may have to quarantine the whole crew. Again, don't assume it's covered by your normal act of God clause. It's not in most places. Also, if you're going to do a COVID rider, I would also put in there a disclaimer for liability for communication of illness. Meaning, if you happen to get sick and you think it's because of one of my people, I'm not liable. Now, will that disclaimer hold up? I think the answer is, in a number of states, yes, if you follow the basic guidelines in your state. And if there's nothing in your state specifically, then what the CDC says. In other words, your people are wearing masks, where when possible, they're spreading out, and they're staying outdoors, except when they have to come in, and then especially they're wearing masks. So if you've got 4 or 5 people on your crew hanging out together, sitting next to each other during a break with no masks on, and then somebody gets sick, I don't think your disclaimer is going to hold up. So, but I do recommend that you look at that disclaimer if you're going to do a COVID rider. Now, again, barriers. Are you responsible, or is the owner responsible for finding their own fence person? If they're responsible and they haven't gotten the barrier yet, will you fill the pool? You may want to say in the contract that we're not required to fill the pool unless you've got the barrier there. And by the way, if you delay and get the barrier there and we can't fill the pool and the pool gets damaged, we're not responsible. Who's responsible for temporary or winter barriers? And again, you want to address the impact of delay if it's not your responsibility. Who's choosing the location of the pool? Now, usually I think it's a great idea to make sure somewhere in your package is a piece of paper that shows where the pool's going to be, a drawing, something, or a description, or a photograph even. So let's make sure we have an agreement as to where that pool is going to be, where you're going to be digging. The last thing you want to do is build a beautiful pool in one spot of the yard and then find out it was supposed to be in a different spot of the yard. However, there can be some minor deviations. So when I write up a contract, I usually put in that deviations of anywhere from 3, 6, maybe even 12 inches in any horizontal direction is still in compliance with regard to the location. Tolerances. Your contract is going to have a description of the pool with depths and et cetera, et cetera. But, nothing is exact to the 1/8 of an inch. So I think it's a good idea to put in that tolerances up to 2 to 3 inches in any dimension are not considered a violation of the contract. You may even want to put in your contract that minor variations of color are not a breach of the contract. So where you can write in some wiggle room into your contract, some safety measure, it's not a bad idea. Now let's talk about the warranty sections in your contract. You need to describe what you're warranting. For example, how long, if it's a concrete pool, how long are you warranting the finish of the pool? What are you warranting against? Typically, when I do a contract for a concrete, I say we warrant that the pool will hold water. If it doesn't hold water, our responsibility is to fix it to the point where it does hold water. Again, is that warranty transferable to a new owner? Some people want to say no. Some people want to say yes because he thinks it makes the customer more likely to do business with him. Nothing wrong with that. Just make sure you've addressed it and you don't leave it to chance. What are the remedies available in the event of a breach? You want to make sure that you limit the remedy for a breach of warranty to the cost of correcting whatever went wrong. You also want to make sure you exclude consequential and incidental damages. In other words, if there's a leak, and then it damages things down the way, you want to make sure you're not on the hook for that. And this is very important. Everybody here installs manufactured component parts. We install pumps, we install filters, we install heaters, we install drain covers, and many of us install vinyl liners or fiberglass shells. I recommend that you always make sure your contract says that we do not provide any warranty for any manufactured component parts. You're getting the manufacturer's warranty only. And that's a pretty good warranty. If you didn't think so, you probably wouldn't be buying from that company. So no need to put yourself on the hook for the pump or the filter or the liner or the shell. Leave that to an issue between the customer and the manufacturer. What are the various things that the owner might do that would void a warranty? For example, this warranty is void if you don't service your pool properly. Some people will only warrant if you use the same company to service the pool. You can do that. The customer may not like it, they might push back, but you could try that. But you probably want to put in there that they must have some regular servicing and maintenance of the water quality in order for you to be responsible. If the owner doesn't keep the pool full, except for a brief period each year, you don't want to be warranting if there's a collapse of the walls or something like that, or if the pool pops, for example. So think of all the things that you expect the owner to do, and that if they don't do, you want to be able to get yourself off the hook on a warranty. And again, when you put in disclaimers, make sure it's conspicuous. A lot of companies will say, if you haven't finished paying me, there's no warranty. I can't guarantee it'll hold up every time, but it's worth putting in there. And if nothing else, it probably increases the likelihood that they're going to remember to make that last payment. Another thing we talk about in contracts is unexpected conditions. And this is where you got to put your thinking caps on. I'll tell you some of the conditions that have shown up when I've talked to contractors when I do their contracts. And that is, these are the kinds of things that can either make a project delayed or can make it more expensive or perhaps impossible. Unexpected hard rock, unexpected soft ground, lack of access to the site. In other words, all of a sudden I can't get my equipment back there. Obviously weather, interference by owner, if they get in the way, or other trades. I mean, I'm sure many of you have experienced situations where you're not the only contractor on the backyard at the time, and you're trying to get your job done in 2 or 3 days, and there's somebody building a shed, and there's somebody doing siding, and everybody's in your way. You can't get anything done. So that's why I often put in that you're not responsible if your delay is caused by the presence or interference of other contractors. What else might go on that list? You tell me. But think about those. Think about the things that you tend to encounter that can screw up your start date. Think about the things that you might encounter that could screw up your completion date. Think about the things you might encounter that might screw up your ability to complete the pool at the price you quote. Put them all down on a list and make sure they're all addressed in your contract. What standard would govern a dispute? I like to go to the ANSI, and now obviously it's PHTA standards. Or we can go to the International Swimming Pool and Spa Code in New Jersey or PA, because that's the law. So one of the clauses I like to add is basically that any dispute, unless otherwise specified in this contract, any dispute as to quality, workmanship, dimensions, etc., will be resolved based on the standard, and you cite the actual standard in place or the code in place. That way, everything that's in that standard and code, including the construction tolerances and the variances, are addressed. If that means if you follow the code and the standard and they don't like what you did, and they call a complaint, you hold up the code, you say, look, your contract says the code will govern. Here's what the code says. That's what I did. And I mean, the customer may not be appeased. I think oftentimes they are, but the bottom line is, in that case, you're holding the cards. You're going to win that dispute. Additional work. Most jurisdictions under the home improvement laws require that if you're going to do additional work, you got to put it in writing along with the price with a separate signature. I've had some clients that I've worked with in recent years. They had a $15,000 job which had about 6 add-ons. The problem is most of the add-ons didn't have written agreements. It was just an email here and there and nothing signed. And so when the customer didn't feel like paying for some of them, they weren't in a particularly good position to sue to recover. So again, each state has a different threshold, but know what the home improvement law is in your state. And again, you know, if you want to talk to a lawyer in your state or someone who knows this business about a rider, a simple 1 or 2 page rider that you can say, okay, This is a rider to the contract dated blank. We've agreed to the additional work. Here's the price, signature. You fill in whatever the blanks in the form. You get it signed. Now your additional work is in writing. Now, if they don't want to pay you, you can hold their feet to the fire. Okay. So again, this I'm going to really date myself with this. This is from an old Marx Brothers movie. We're basically tearing up a contract that makes absolutely no sense. The bottom line is, make sure your contract works for you in 2020. Not in 1990 or 2000, not when, the prior owners of the company, whether it's friends or family or otherwise, were running the business, and not necessarily in 2019. We're seeing things this year that we never thought we would see in our lifetime. And make sure that you're satisfied that your contract works for you today. Okay. So let's talk for a few minutes about contract with GCs and subs. Typically, GCs, they throw their form at you under the AIA. But again, that's not set in stone or concrete or fiberglass or even vinyl. So if you have a problem with certain terms, make sure you tell them. Now, look, if they say you do it this way, you sign this contract, you don't get the job, I'm not here to tell you don't take the job. I'm just telling you, look at what's in the contract. Look at what terms they're putting in there and what you're expected to do, and make sure that you're willing to take on the job. What does the contract say about indemnity and insurance? Typically, if they're the GC, you're going to indemnify them. That their contract will probably specify how much insurance you have to have. Make sure you have that much. And make sure that you've addressed the contingencies necessary to timing the access. I mean, again, if a GC is hiring you, they're probably hiring more than one contractor. So find out, what's the timing here? When do you expect me to do my work? Are people going to be in my way? What happens if I can't get to my work or finish my work because they're in the way? Have that conversation. And if necessary, have the form amended to address it. Now, payment schedules. I should have talked about that going back to your contracts with your customers too. Every contract with a customer needs to have a payment schedule. How much, what percentage are you taking at each stage? And in New Jersey, for example, you cannot accept the final payment until the job is done. So make sure you understand that. So what are you getting right up front? What are you getting at each different stage? Make sure the stages are set forth clearly. And in New York, there are certain requirements about putting that money in escrow and saying in your contract that you're going to put it in escrow. So remember that as well. But even with your GCs, what are the payment schedules? Who is supposed to be contacting the homeowner? Do they expect you to do it, or do they want you to stay away from the homeowner and leave it to them? So if a question comes up, who are you supposed to ask? And make sure that the agreement doesn't put you as responsible for the entire site when you're just one of the subs. So again, look at your contracts. And again, now when you're hiring a subcontractor, again, what form are you using? Does that form require them to indemnify you? Does your form require your sub to provide insurance, and how much? Does your contract make it clear whether your sub is permitted or not permitted to engage with the homeowner? What's the payment schedule? What are their responsibilities? What are your responsibilities? Okay. Now, we all buy products too, and we have contracts with our vendors. You may say, wait a second, I never signed a contract with my vendor. I just get an invoice. Well, look at the back of the invoice. That's your contract. So when you get, look, there's a lot of things that go into deciding who you're going to buy from and on what terms. And I'm not saying just to go with the one that has the best terms and conditions on the back. I mean, you go with the price, you go with the quality, you go with the company that has a history of standing behind their product. There's a lot of things to go into. But every once in a while, just for kicks and giggles, read the back of one of the invoices. Make sure you understand what it says and what it means. Even if you're not going to stop using them, even if you're not going to be able to change their form, at least understand what it is you're signing on to. Now, obviously, the most important thing you want to do is make sure that if something goes wrong with a product we bought and installed, that there's somebody behind me to stand behind the product and take care of it. So again, when you decide who to buy from, make sure you're satisfied that that company is going to stand behind you if something goes wrong with their product. And there are a lot of different ways that they can stand behind you. One is what's called a vendor's endorsement. What does that mean? That means that they're agreeing to put you as an additional insured on their insurance policy. That means that if there's a problem with that product and there's a claim or a lawsuit, their insurance policy not only defends them, but defends you. And since none of us like to have our own insurers spend money on our behalf, that can make a big difference. If you're not getting that, make sure at least that there's something in there that indemnifies you in the event that there's a problem, a defect in the product. If not, then you've left the common law remedies of indemnity and contribution, which is still worth something, but may not be as valuable if you're in a courtroom. And again, when you hire subs, make sure they're indemnifying you. You know, one of the things it's a good idea to do with a subcontractor is request that they have you listed as an additional insured on their policy and ask for proof of their insurance. In fact, I would even ask for a copy, if you're dealing with a new subcontractor, I would even ask for a copy of their policy itself, just to see that it actually is a 30, 40, 60, 70 page piece of paper there, not just a certificate. Going back to being protected from your vendors, this is the most important thing to remember. Whatever level of protection your manufacturer or distributor is providing to you, it's only worth a nickel if you follow their instructions. If you follow their instructions in the installation of their product, meaning how you install it, making sure all the components are delivered. If they tell you to deliver written materials, deliver the written materials. If they tell you to put up a sticker, put up a sticker. If they tell you to put something 3 feet apart or 4 feet apart, whatever they tell you, make sure you follow the instructions that they give you, then it's on them. If you don't follow the instructions, it's on you. And most of them are going to step aside. And I can tell you, I represent a lot of manufacturers, and I've been in that unpleasant position where my client, the manufacturer, has a witness at a deposition, and the lawyer representing the injured party says, "Sir, did this contractor follow your instructions when they installed your liner, your pump, your this or that?" And I've been in situations where the person had to say, "No." You don't want to put your manufacturer in that position. Okay. The next thing I'm going to talk about is reviewing or creating customer safety materials. Now, if you're installing vinyl or one-piece pools, you get a pretty elaborate package with that liner or shell. It's got signs, it's got a manual, a safety manual in a lot of cases. A lot of companies would also throw in some of the PHDA sensible way to enjoy your pool book, or children aren't waterproof, or things like that. Whatever they put in that package, make sure that package gets into the hands of the owner. And preferably, make sure that the owner signs off that they've gotten it. Now, in the old days, meaning pre-COVID, that meant, wandering into their kitchen, handing it to them, and asking to sign a piece of paper. Now that we're distancing, I think you might have to do it a little differently, but make sure you leave the package for them. And then I would follow up with a call and an email saying, "Mr. or Mrs. Customer, I just want to let you know that when we finished your job, we left you the following safety materials on your doorstep or inside your door, whatever it is. I would appreciate your replying to this email to confirm that you got it." Okay? Take that reply, save it into your customer file. There's your proof. Okay? But now, if we're doing concrete, we have a different challenge. Normally, I'd ask for a show of hands here, but I'm just going to go on the assumption that at least somebody here is doing concrete in addition to vinyl or fiberglass. And the bottom line is, when you're doing concrete, nobody's giving you all those materials. You're the manufacturer of the pool, basically. So one of the things I strongly recommend concrete or gunite installers to do is to create your own safety package. Put together a safety manual, and throw in some of the goodies that PHTA provides for very cheap price, and maybe even some of the goodies that the Consumer Product Safety Commission provides for nothing. You still have a duty to warn, and you need to create something that's, I think, comparable to what the vinyl customers and fiberglass customers are getting. So what goes in a safety package if you're creating one? First of all, a manual. Just like any product I buy. I just bought an automatic guitar tuner. It's got a manual. It's like 3-4 pages. It's got an instruction book. Everything got an instruction book. You need to provide an instruction book. It's not enough just to provide the manuals for the pump, the motor, and the filter. There needs to be a manual for the pool. And I would include in that package no diving signs for the customer for an in-ground pool. An above-ground pool, you're supposed to put them on yourself under the standard, so you definitely want to make sure they're on. And here are some of the things you can throw in that package. They really cost very little. The sensible way to enjoy your in-ground swimming pool. And again, these are all updated now with the PHTA logo on them. So take a look at these. Go on the PHTA site or go to NESPA, go to the store. I mean, you can buy a box of them for a few bucks. And the Consumer Product Safety Commission, and you see that website there, poolsafely.gov, they give these little brochures out for free. So you want to stockpile some and stick one in each envelope, it's a great idea. Again, what goes in a manual? If you're a concrete builder and you're creating your own, some basic do's and don'ts around the pool. Do supervise children. Do maintain the pool. Don't, play around with chemicals. Don't, don't dive. Don't allow diving in the shallow end. If there's no diving equipment, then it's a non-diving pool. Don't swim alone. Don't mix alcohol and swimming. All the things that you want to put in an instruction book. And probably on entrapment, the one thing that I always put in the manual for entrapment, when a cover is broken or missing, don't use the pool, call me. Chemical storage and handling, you can go about it 2 different ways. A number of clients of mine simply say, we don't want our customer touching chemicals. We're going to say in our contract or in our manual, you shouldn't touch chemicals. Use a professional service provider or for somebody else. Other companies figure, you know what, they're going to do it themselves. I should provide them with some basic tips on how to do it safely. It's not a right or wrong answer there, but you should do something about it. The manual should tell them about managing water quality, water visibility. Any day you come out to use your pool and you can't see the deepest part of the water, at the bottom through the water, is a day you shouldn't be letting anybody in your pool. Get somebody in there, get it cleaned, and then go back to using the pool. Electrical appliances, what you should not put around the pools, ground fault circuit interrupters. I got that GFCI backwards, I apologize. And again, when you're installing a liner or a vinyl pool, are you following the instructions? Are you delivering to them all the safety materials? And finally, can you prove it? And that's where the sign-off comes in, whether it's by email or by written piece of paper. So lastly, I would say that about 2/3 of consumer to business lawsuits start not because of the work or the original dispute, but because somebody felt like they were being ignored. Their emails or their calls were not being returned. So it's very important to train the people on your staff who are going to do this, or yourself, if you're going to do it, on dispute resolution. How to de-escalate, how to deflate. All right, number one, return all calls and emails, especially the angry ones. The angrier the email or the call, the sooner you want to respond, because otherwise that anger is festering every second that you delay in getting back to them. If it turns out they're wrong and you were right, and you have the contract language to prove it, or the email between them to prove it, explain to them. Take the time to explain why it is that you're right. Where it's practical and it's in your interest to accommodate, you can. Where you feel like you got to dig your heels in, you can, but at least this way you have the contract language on your side to show why you're not required to and why they're wrong. So again, you kind of I'd rather do this than have this. So to wrap up, do the right thing, be able to prove you did the right thing, fewer legal issues, more satisfied customers, more satisfied GCs and subs, reduce liability, and probably reduce insurance premiums. So with that, we've set aside about at least 10, 15 minutes here. So are there any questions so far?
We don't have any just yet, Steve.
All right, so let's give a minute or two. Okay, I mean, that was a lot of material to cover without a question. I can tell you, usually when I do this in person, I can't even get to the end because the number of times I'm interrupted, with various questions. But again, while we're waiting for questions to come in, I want to go back to the contract again for a moment. Because this is, again, the code is your Bible with the inspector. The contract is your Bible with the customer. And you want to make sure that if anything goes wrong, the answer is in the contract. And, a lot of people say, well, what should I put in there for contingencies? And the answer is, okay, here are some of the things that I've thought about, but what about you? So for example, some of my clients will put in that this contract assumes that I'll be able to excavate your project in 1 day using the following equipment or equivalent. That's one way to provide a clear definition. If I can't get it done within 1 day using that equipment, then there's going to be an extra charge. Or this contract assumes that I'm going to have soil of a certain minimum thickness or hardness. And then you can specify, and then that way at least you know whether what you found is that or not. Another issue that I think is important to address in the contract is drainage. And by that I mean your land draining water away from the pool. I'll tell you a quick story. I actually was called in to help a contractor who was sued in upstate New York. And the problem was after the job, the customer got impatient waiting for backfill material. So the customer decided they were going to get somebody else to do the backfill. And then the customer had the land landscaped to the point where water was draining into the pool rather than out of the pool. You put those two situations together, you can imagine some of the problems. So when the contractor was defending the claim, I said, well, does your contract say you're not responsible if they do the backfill? No. Does your contract say that it's their responsibility to make sure that the land slopes away from the pool? No. Does your contract say that under no circumstances are you liable for more than the cost of the original contract? No. Okay, well, this person has updated their contract, but any of those things in the contract would have helped produce a different outcome in that case. So again, think of the things that might go wrong or have gone wrong and make sure that you're addressing them. Okay.
We do have a couple of questions.
Good, let's go.
That just came through. So the first one that came through is asking, do you work with builders and service companies in Pennsylvania or just New York?
Pennsylvania, New Jersey, New York, Connecticut, Maryland, Michigan, I can keep going on.
Perfect. And when is it acceptable to use an email or text response versus an actual signature?
Texts are trickier because then you got to save a screenshot. I'm not saying you can't do it. I would much prefer to rely on email rather than a text because it's a lot easier to save. If you're going to rely on a response by text, then make sure you take a screenshot of the exchange and save it. Perfect.
John is asking if we will get a copy of all this information. You're going to provide the slides, correct?
I think you already have them, Jessica. I sent them the other day, but I can resend them if you need.
I do believe I have your updated version. Yes.
Good. Feel free. Yes. And Phil and Todd, feel free to distribute it to anybody at your chapters who ask for it.
One last question. Are there any resources that they should keep an eye on to help with the stay up to date on the topics that you've covered and related issues?
Yes, phta.org, first of all. I mean, and NESPA and your chapters, all right? We're keeping on top of things for you. So you go to, and PHTA page has a bunch of updates for periodically. But also, remember, at NESPA, they're constantly keeping an eye on things going on in Pennsylvania, New Jersey, Connecticut, and New York. So if you have a question about something, check with them. But again, yeah, that's why you're paying your dues.